Good day, class. Welcome to Chapter 3, Part 3 of the Law on Obligations. In this video, we shall be discussing about joint obligations, solidary obligations, divisible obligations, and indivisible obligations. So let's start with joint obligation. So we look at Article 1207. So let's discuss first the kinds of obligations according to number of parties. We have an individual obligation wherein there is only one obligor and one obligee. Then we have a collective obligation, which means that where there are two or more debtors and or two or more creditors. They may either be joint or solidary. So let's go to the definition of joint obligations and solidary obligations. A joint obligation is one where the whole obligation is to be paid or fulfilled proportionately. So the key word here is proportionately by the different debtors and or is to be demanded proportionately by the different creditors. So we equate a joint obligation with a proportion. Okay, so we have to it is fulfilled proportionately depending how many debtors and how many joint creditors there are. Now in a solidary obligation, it is one where each one of the debtors is bound to render and or each one of the creditors has a right to demand from any of the debtors the entire compliance with the prestation. Now, it is best to learn this by examples. So let's discuss first the general rule, all right? So the general rule, assuming that the problem is silent, the general rule is that a collective obligation is joint, all right? So why is this the presumption? Why is the general rule that the collective obligation is always joint? The presumption is that it is joint because it is less burdensome on the part of the debtors. All right. So we always have to protect. We have to protect the interest of the parties. And in this case, we have to lessen the burden of the debtor in this case. Okay. So if the intention is not manifested, if it is not apparent, the presumption is that it is always joint. All right, because it is less onerous on the part of the joint debtors. Okay. So the exceptions to the general rule are, for one, the obligation expressly so states. Number two, the law requires solidarity. Number three, the nature of the obligation requires solidarity. So these are the three exceptions. So in number one, it has to be, kung solidary yan, it has to be very clear. There has to be wordings that indicate solidarity. Otherwise, the obligation will be presumed joint. So what are the words used to indicate solidarity? We have jointly and severally, jointly or severally, solidaria, in solidum, together and or separately, individually and or collectively, juntos o separadamente. It's Spanish. I promise to pay, signed by two or more persons. Class, take note, I promise to pay. Mag-isa lang, no? I promise to pay. Pero maraming nakapirma. In that case, the obligation is solidary. Paano kapag we promise to pay, tapos maraming nakapirma? Then the obligation is joint. Alright? E dito, I promise to pay. Isa lang yan, pero maraming nakapirma. So that's a solidary obligation. So let's talk about the joint obligation. So let's use this as an example. All right. A, B, and C oblige themselves to pay D, E, and F 90,000 pesos. So himayin muna natin. Sino ba dito ang debtors? Ang debtors dito, si A, si B, at saka si C. Alright? Sino dito ang creditors? Si D, si E, at saka si F. What is the object here or the prestation? The payment of 90,000 pesos. Now class, look at the statement. A, B, and C oblige themselves to pay D, E, and F 90,000 pesos. Paano malalaman kung ito ay joint obligation? Meron bang nakalagay? Meron bang nakasulat na joint ito? Wala nakasulat kung joint ito. Wala rin nakasulat kung solidary ito. Therefore, what is the presumption? The presumption is, or if the problem is silent, the obligation is joint. Alright? So let us discuss the steps. Divide the total credits. Bilangin mo kung ilan yung creditors. Ilan yung creditors? Tatlo. O 90,000 divided by 3, you have 30,000 pesos. And then, divide the individual share of each creditor to the number of joint debtors. So 30,000 divided by 3, that's 10,000 pesos. Now in the next slide, malalaman natin kung paano dito yung bayaran. Alright? Pwede bang singilin ni D? Look at the chart class. Pwede bang singilin ni D si A ng 90,000 pesos? The answer is no. Alright? Ngayon, si D kasi di ba tatlo sila? So 90,000 divided by 3. So si D, si E at saka si F, they are entitled to get 30,000 pesos each. Si D, pwede ba niya kunin kay A ang 30,000 pesos? The answer is no pa rin. Alright? Kasi si A, si B at saka si C, they are joint debtors. So yung 30,000 yan, divide yan kung ilan yung mga joint debtors. So magkano pwede kunin ni D kay A? 10,000 pesos lang. Okay? So this is a clearer narration of the example. All right, this is a clearer illustration. So let's look at the tables here. No? So yung makita nyo yung steps. No? So divide the total credits, divide the individual share of each creditor to number of joint debtors. So same yung steps. Pero dito may malinaw na illustration. Alright? Si A, magkano yung babayaran niya? Ang total na babayaran ni A, 30,000 pesos din. Okay? Pero ang pwede i-demand sa kanyang amount ni D ay 10,000 pesos lang. Ang pwede sa kanyang i-demand na amount ni E ay 10,000 pesos. Si F, 10,000 pesos din. Okay? Ito namang si D at saka si F, hindi sila pwede sumingil more than that amount, more than 10,000 pesos. Okay? Ito class, no? Mas madali for the debtors ang joint obligation. For the creditors naman, syempre mas mahirap ang joint obligation. Kasi lahat ng mga joint debtors na to, dapat singilin nila. Dapat gumawa sila ng demand. Okay? Si debtor B, ganun din. So payment to D, E, and F of only 10,000 pesos each. Si C, debtor C, ganun din. Payment to D, E, F of 10,000 pesos each also. Okay? Naman, let's talk about a solidary obligation. All right? A, B, and C oblige themselves solidarily. So dito class merong wording, no? A, B, and C oblige themselves solidarily to pay D, E, and F, who are solidary creditors, 90,000 pesos. Okay? So in that case, class, any of the creditors may demand the whole amount of 90,000 pesos from any of the debtors. If D makes a demand of 90,000 pesos from A and A pays him, D has the obligation to pay E and F their shares of 30,000 pesos each. At the same time, A can demand reimbursement of 30,000 each from B and C. Such agreement is only among themselves. So ito class, no? So si D, pwede niyang singilin kahit sino kay A, B at saka kay C yung amount na 90,000 pesos. Okay? So paano pag nagbayad na si C kay D? Pwede mo bang sumingil si E o kaya si F kay A o kaya kay B? The answer is no. No more. Hindi na pwede. Because the obligation is considered fully paid already. Okay? Ngayon, as between the creditors, sila, dapat magbabayaran sila. Kung sino yung kumolekta dito sa example, ang kumolekta dito sa example ay si D. Kung kumolekta siya ng 90,000, he has to pay E and F 30,000 pesos each. Okay? Kailangan niya ibigay yung share, hindi pwedeng sa kanya lang yan. But that is only among themselves. Sila, pwede sila magkasuhan. Sila. But as far as the debtors are concerned, bayad na sila. Ngayon naman, pumunta tayo sa side naman ng debtor. Ang nagbayad dito ay si A ng 90,000 pesos. Bakit siya nagbayad? Kasi siguro siya yung siningil sa kanya gumawa ng demand, si D. Okay? Pag ganun ba, walang gagawin si B at saka si C? Sabihin nila, oh sorry ka kasi ikaw nagpapakita sa kanya. Ikaw lang mag-shoulder niya. The answer is, they have to reimburse A for their shares. So si B magbabayad ng 30,000 kay A, si C ganun din. Magbabayad din ng 30,000 kay A. Kung di sila magbayad, pwede silang kasuhan ni A. But that is only among themselves. Wala nang pakialam ang creditor dyan. Okay? So that is a solidary obligation class. Yan, can there be a mixed solidary obligation? Pwede ba sa isang side, joint, sa isang side, solidary? There's no prohibition. Let's talk about a joint indivisible obligation. That we shall be discussing this more later on. So in a joint indivisible obligation, right? The obligation is joint, but the object is indivisible because the object or subject matter is not physically divisible into different parts. It is joint as to the liabilities of the joint debtors, but indivisible as to compliance. Okay? Anong example niyan? Example niyan, si A, si B, at saka si C, they oblige themselves to deliver a specific car to D. All right? Ngayon, joint obligation yan, but the car is indivisible. Bakit indivisible yung car? Kasi pwede mo ba hatiin yung car? The answer is no. Pwede ba yung harap muna, yung gitna, tapos saka yung likod? Hindi. A car is considered indivisible. Kung ibibigay mo yan ng buo. Ngayon, di ba, ang joint obligation, alright? Ang joint obligation, proportionate dapat. So itong sa obligation, joint obligation to deliver a car, no? Tapos kung ikaw si D, paano mo sisingilin yung delivery ng car? Okay? Kung papayag si A, si B, at saka si, you have to proceed against all of the joint debtors. Hindi pwedeng isa lang. Kasi joint yan eh. So you have to proceed against all of the joint debtors. Ngayon, kung payag, if A, B, and C joint debtors are all willing to deliver the specific thing, then you will have no problem. Eh paano kapag ayaw ni A? No? Pag ayaw ni A na i-deliver yung kotse, pwede mo ba i-deliver yung kotse? Pwede ba sabihin ni B at saka si O yung ano na lang, yung 2/3 na lang ng kotse ang i-deliver namin sa'yo? Hindi pwede yun. Okay? So ano ang gagawin in that case? So the obligation, kasi once na may humindi dyan na joint debtor in a joint indivisible obligation, hindi ma-deliver yung prestation. So in that case, the prestation is converted to one for damages. So damages na lang. Okay? Damages na lang ang pwede singilin ng creditor dito sa mga joint debtors na to. Of course, ang magiging liable talaga dito is yung humindi, yung umayaw, no? Si A. Alright? If one of the debtors is not compliant, the liability is converted into one for damages. We shall be discussing this again later on. So ito, no? So sa example natin, A, B, and C are jointly liable to give D a car valued at 240,000 pesos. On the date of delivery, A and B are willing to deliver, but C is not. So D has no cause of action against C alone because the obligation is joint. C is only liable for a proportionate amount. Because the object is indivisible, the debt can only be enforced by proceeding against all debtors A, B, and C. Because C is non-compliant, the whole liability of delivering the car becomes converted into one for damages. A and B are liable for 80,000 pesos each without damages. Okay? C is liable for 80,000 pesos with additional payment of damages. Bakit si C lang ang magbabayad ng additional damages? Alright? Kasi siya yung umayaw dun sa joint obligation. Kasi payag naman si A at saka si B. So technically, they're not at fault. Pero si C, siya yung umayaw, magbabayad siya ng additional damages. So, joint indivisible obligation. In case there are two creditors in a joint indivisible obligation, the debtor or debtors can insist that all joint creditors accept the indivisible object together. If either of the creditors refuse, the debtor can refuse to deliver the indivisible object. So in this case, ano gagawin kapag merong refusal by the creditor? The debtor can deposit or consign the indivisible object in court. Right? So let's not forget the word consignation. So what's the difference between indivisibility and solidarity? Indivisibility refers to the prestation. Solidarity refers to the juridical or legal tie. Indivisibility, in indivisibility, only the debtor or debtors guilty of breach is or are liable for damages. In solidarity, all of the debtors are liable for the breach committed by a debtor. In indivisibility can exist although there is only one debtor and one creditor. In solidarity, there must be at least two debtors or two creditors. In indivisibility, the others are not liable in case of insolvency of a debtor. In solidarity, in case of insolvency of a debtor, the others are proportionately liable. Solidarity is not affected by diverse stipulations. There may be a solidary obligation, although the parties may not be bound in the same manner and by the same periods and conditions. The creditor may bring his action in toto. Ano sabihin na in toto? In total, no? In totality. The creditor may bring his action in toto against any of the solidary debtors, less the shares of the other debtors with unexpired terms or unfulfilled conditions. Upon the expiration of the term or the fulfillment of the condition, the creditor will have the right to demand the payment of the remainder. Solidarity is not affected by diverse stipulations. Example, A, B, C, and D oblige themselves solidarily to pay E 20,000 pesos as follows. A, to pay by installment at the rate of 1,000 pesos a month to start in July. B, to pay in September. C, to pay in December. And D, if E passes the CPA board examinations. Sa class makita nyo dito, hindi sila sabay-sabay na magbabayad. Pwede ba to itong kaso? Yes, pwede. Pwede yan. So paano pag ganyan? In July, so nasa dito in July, no? Yung mag-start yung payment ni A, no? In July, E can demand only 1,000 pesos from A. E can also make a demand from B, C, and or D, the 1,000 pesos share corresponding to A. Okay, class? So tigil muna tayo dito. So ito so si A lang 'di ba yung sinasabing liable. All right? Sa 1,000 pesos a month start in July. Siya yung pinakauna. Pero pwede rin ba singilin ni E yung iba ng amount of 1,000 pesos? Yes, pwede because the obligation is solidary. Okay, pero yung yung share ni B, yung share ni C, hindi pa pwedeng singilin. Pero dun sa 1,000 pesos, pwede singilin yung iba, hindi lang si A. Okay? But E cannot recover yet the shares of B, C, and D which are not yet due and demandable. Anong sabihin that? And yung amount na other than 1,000 pesos, hindi pa pwede singilin. 1,000 pesos lang pwede singilin, pero kahit sino sa mga yan, si A, B, at saka si D, pwede singilin because the obligation is solidary. In December, E can recover from any of the solidary debtors the share corresponding to C in the amount of 5,000 pesos plus such amounts from the shares of A and B which have not yet been paid. So yung mga tigwa 1,000 pesos, pwede rin singilin kahit kanino. Alright? Pati yung share ni B, pwede rin singilin kahit kanino. Okay? If E passes the CPA examination, the obligation of D to pay 5,000 pesos arises. This amount can be demanded from any of the solidary debtors. Okay? So itong scenario na to, pwede to. So act of solidary creditor, useful or prejudicial to solidary co-creditors. So we're talking about the solidary creditors in this case. No? Solidary creditor may do any act beneficial or useful to the others. Okay? If the solidary creditor performs an act prejudicial to his solidary co-creditors, he shall be responsible to the others for damages. But as far as the debtors are concerned, the act is valid. Example, A owes B and C, solidary creditors. Again, class, yung pag solidary yung obligation, dapat naka-mention yan or merong wordings that will indicate solidarity. So A owes B and C, solidary creditors, the sum of 10,000 pesos. In case of remission or condonation effected by B. Again, class, no? What do we mean by remission or condonation? Sabihin, parang pinawalang halaga na, pinawalang bisa na, pinagbigyan. Parang hindi na sisingilin. Okay? In case of remission or condonation affected by B. So si B isa sa mga solidary creditors, right? In case of remission or condonation affected by B, the obligation will be extinguished. Okay? But B has to reimburse C for the latter's share. Okay? Kasi this is a solidary obligation. Assuming this is a joint obligation, class. Tapos A owes B and C who are joint creditors the sum of 10,000 pesos. Now si B made a condonation in favor of A. Si C ba, pwede pa siya maningil kay A? Yes, pwede. Alright? Pagkano sisingilin ni C kay A? E di 5,000 pesos. Okay? Kasi ang pwede lang i-condone, o pwede lang magkaroon ng remission, assuming this is a joint obligation, ang pwede lang i-condone ni B is his share of 5,000 pesos. Pero ngayon kasi, this is a solidary obligation. Pag solidary obligation, pag pinagbigyan ni B si A, edi he must be referring to the whole amount of 10,000 pesos. So as far as A is concerned, edi wala na siyang obligation. Okay? Pero teka muna. Paano naman si C? Wala siyang kamalay-malay. Na-condone pala si B ng debt, no? So in this case, class, so dapat ang ibayad ni B kay C is 5,000 pesos kasi nawalan si C. Kasi hindi naman payag sa condonation or remission si C. Now what if, class? What if pwede bang ang i-condone or ang remission partial amount lang? Yes, pwede 'yon. Okay? Pwede naman 'yon. But of course, the person, the solidary creditor who effected a partial condonation has to give the share to the other solidary creditors. Okay? Assignment by solidary creditor of his rights. Is this allowed? No. A solidary creditor cannot assign his rights to a third person without the consent of other solidary creditors. Okay? The assignee. Sino ba yung assignee? Yung assignee ay yung a-assignan niya ng kanyang right. No? The assignee may not have the confidence of the original solidary creditors because if the assignee receives the payment, he or she may not give the shares of the others. Okay? If the assignment is made to a co-creditor, then no consent is necessary. Alright? So kumbaga merong mutual agency among the solidary creditors. So hindi pwede na i-assign kung ikaw yung isa sa mga solidary creditors, hindi mo pwede i-assign yung right mo to a stranger. Okay? Unless all the other solidary creditors agree. Payment to any of the solidary creditors, general rule. The debtor may pay any of the solidary creditors. Exception: when a demand, whether judicial or extrajudicial, is made by any of the solidary creditors, the payment must be made to him or her. Okay? So ito class, kung meron na una sa mga solidary creditors na mag-demand, dapat sa kanya magbabayad. So liability of a solidary creditor in case of novation, compensation, confusion, or remission. So class, itong novation, compensation, confusion, or remission, these are modes of extinguishment of obligations. We will discuss more about that later on. So novation, paggawa ng bagong agreement. Okay? Compensation, parang may utang kayo sa isa't isa, no? Tapos confusion, ano yan, parang the debtor and the creditor become one person. No? We will discuss more about that later on. Remission, ito yung condonation. Okay? The creditor who executed any of these acts is liable to his co-creditors for their corresponding shares because such act is prejudicial to them. Example, A obliged himself to pay to solidary creditors B, C, and D the amount of 30,000 pesos. If B condones the whole amount of 30,000 pesos, he shall be obliged to pay 10,000 each to C and D. So I hope you get this class, no? Kung bakit 10,000 each si C at saka si D. Kasi divided by 3. No? B, C, and D, ilan sila? Tatlo. So divided by 3 is 10,000. So dapat may 10,000 pesos each sila. Effects of payment by solidary debtor. So among the solidary debtors and creditors, payment made by one of the solidary debtors extinguishes the obligation. Among the solidary debtors, after payment of the debt, the paying solidary debtor can demand reimbursement from his co-debtors for their proportionate shares with interest from time of payment. In case of insolvency of any of the solidary debtors, the others assume the share of the insolvent one pro rata. Okay? So ito class, it gets interesting kasi merong insolvency among one of the solidary debtors, no? Ito pala class, paano kapag joint obligation? Nagma-matter ba ang insolvency? The answer is no. All right? No in the sense na walang pro rata na magaganap na reimbursement. Kasi for example, si A, B at saka si C joint debtors, no? Tapos ang obligation nila is to pay 30,000 pesos to D. Naging insolvent si A. Paano 'yan? Di sorry na lang si D, no? Ang pwede niya kolektahin kay A, di wala kasi insolvent siya. Ang pwede niya kolektahin kay B, di 10,000, kay C naman 10,000. So in total, he only gets 20,000 pesos. Well, ganun talaga. No? And it becomes more complex for solidary debtors. Kasi pag ganyan na merong reimbursement, maghahati talaga sila pro rata. Ngayon, paano kung meron naging insolvent? Di yung share na solidary debtor na yon, paghahatian pa ng mga natitira na solvent, not solvent, sorry. Mga hindi insolvent, no? Paghahatian siya ng mga hindi insolvent na solidary debtors. So effects of payment by solidary debtor. Among the solidary creditors, the receiving creditor is jointly liable to the others for their corresponding shares. So effect of payment by solidary debtor after the obligation has prescribed or become illegal. The paying solidary debtor cannot demand any reimbursement from other solidary debtors. Okay? So ibig sabihin class, paano kung nag-prescribe na yung utang, no? Let's say si A, B at saka si C. They are liable solidarily to D in the amount of 30,000 pesos. Okay? Di ba napag-usapan natin, pag nagbayad si A ng 30,000 pesos kay D, pwede siya humingi ng reimbursement kay B at saka kay C na magkano? Tig 10,000 pesos. Paano class kapag nag-prescribe na yung utang? Sabihin, hindi na ningil si D. Hindi na ningil si D ng in 10 years time. No? Hindi siya naningil ng utang na 30,000 pesos kay A, B at saka kay C. Now class, pag more than 10 years na, tapos merong written agreement, merong written contract na magbabayad si A, si B at saka si C who are solidary debtors kay D. No? Let's say nag-prescribe na yan after 10 years. Nagbayad pa rin si A, no? Kasi kagandahan ang loob niya. Nagbayad siya ng 30,000 pesos. Let's say on the 12th year, nagbayad si A ng 12,000 pesos. Sorry, ng 30,000 pesos kay D. Alright? Pwede ba humingi ng reimbursement si A kay B at saka kay C? The answer is no more. Alright? Kasi in the first place, dapat hindi nagbayad si A. Okay? Kasi bakit siya nagbayad? Well, pwede siya, okay naman yung bayad niya kasi that's his natural obligation. No? But that's not a legal obligation anymore. Kasi prescribed na yung utang and nagbayad pa rin siya. Then bakit siya hihingi ng reimbursement kay B at saka kay C? In the first place, dapat hindi siya nagbayad. No? Ganun talaga. No? So he cannot ask for reimbursement. So let's talk a little bit about prescription class. All right? So rights and actions are lost by prescription. Ano ba yung sabihin ng prescription? Hindi ito yung kailangan sa drugstore. No? Yung sabihin ng prescription, this is the length of time. This is the length of time where rights may be had or actions may be lost. Okay? Rights and actions may be had or rights and actions may be lost. Okay? So under Article 1106, 10 years yung reckoning period. So upon a written contract, upon an obligation created by law, upon a judgment. So 10 years time. 6 years naman kapag oral contract or quasi-contract. You already know what a quasi-contract is. Oral contract kapag verbal lang. So 6 years. 4 years naman kapag injury to the right of the plaintiff or upon a quasi-delict. Sabihin class, within 4 years, dapat magkaso ka na ng quasi-delict. Otherwise, the action will have prescribed. Hindi ka na pwede mag-file ng kaso. Okay? Let's say nabangga ka, tapos wala kang ginagawa for 5 years. Pwede mo ba kasuhan yung tao na nakabangga sa'yo? No. Alright? Kasi masyado kang natulog. Tinulugan mo yung mga karapatan mo. You slept on your rights. So effect of a remission of share. If a payment is made first by any solidary debtor, the remission or waiver is without effect. Kasi nauna magbayad. The obligation is extinguished. A and B are liable in solidum to C in the amount of 1,000 pesos. B paid the whole amount first before remission. Because of this, any future remission is without effect. A is liable to B for 500 pesos. Kasi nauna before the remission. If payment is made first by any solidary debtor, the remission or waiver is without effect. The obligation is extinguished. A and B are liable in solidum to C in the amount of 1,000 pesos. C remitted A's share. Subsequent payment by B of 1,000 pesos to C will not entitle him to a reimbursement from A, since the remission extinguished the obligation with respect to A's share. However, B can demand the return of 500 from C under the principle of solutio in debiti. Okay? What if there was a solidary debtor whose share was remitted, but one of the other solidary debtors became insolvent? Should he share pro rata with the other solidary debtors? The answer is yes. A, B, and C are liable in solidum to D in the amount of 3,000 pesos. D remitted the share of A. B then pays the whole amount of 2,000 pesos. E then demands reimbursement of 1,000 pesos from C. However, C becomes insolvent. So in this case, A then becomes liable to B for the amount of 500 pesos. Okay? So dito class, no, kahit remitted yung share ni A, pero naging insolvent naman yung isa sa mga parties, magiging liable pa rin si A for reimbursement in case maging insolvent yung isa sa mga solidary debtors. Okay? So there is no right to reimbursement in case of remission of the whole obligation. So this pertains to remission of whole obligation. The solidary debtor who is granted remission of whole obligation pays nothing to the creditor because it is essentially gratuitous. For example, no? So A, B, and C, they are solidarily liable to D in the amount of 30,000 pesos. Kasi D, dahil gusto niya si A, ni-remit niya yung as far as A is concerned, gusto niya i-remit yung whole obligation. No? In that case, pwede mo mag-demand ng reimbursement si A. Pwede mo sabihin ni A na, dahil sa akin, wala na tayong utang. Pwede mo siya humingi ng pera kay B at saka kay C? The answer is no. Alright? Kahit sinasabi niya magaling siya na na-remit yung na nagkaroon ng remission yung debt nila, hindi siya pwede humingi ng reimbursement. Rules in this thing has been lost or prestation has become impossible if the loss is without the fault of solidary debtors and before delay. Again, class, remember the general rule. No demand, no delay, subject to certain exceptions. The obligation is extinguished. Okay? Example, A, B, and C promised solidarily to deliver to D a particular truck valued at 1.5 million pesos. If the truck is lost through a fortuitous event and the solidary debtors have not incurred in delay, the obligation is extinguished. Again, class, no? Loss of the thing due, tapos specific object, the obligation is extinguished. If the loss is due to the fault of a solidary debtor, all solidary debtors become liable. The innocent solidary debtors may ask for reimbursement from the erring solidary debtor. Same example above with the truck. But the truck was lost through the fault of C. Or let's say dahil negligent siya, na nasunog niya yung kasi nagpaputok siya, tinamaan niya yung truck, nasunog. No? A and B shall also be responsible to the creditor even if they were not at fault. Hindi pwede sabihin ni A at saka ni B, teka, si C lang may kasalanan, hindi kami. Hindi pwede yun. Okay? However, they can ask for reimbursement from C, the erring solidary debtor. Sabihin class, itong creditor, pwede niya pa rin habulin kahit sino, kay A, kay B, o kaya kay C, yung value ng truck, no? Which is 1.5 million pesos. Okay? But of course, pwede humingi ng reimbursement yung nagbayad dun kay A. Dun sa solidary debtor lang pala. Sa kanya lang. Dun sa erring solidary debtor yung naging negligent. Rules in case the thing has been lost or the prestation has become impossible. Number 3, if the loss is without fault of solidary debtors but after delay. Nagkaroon ng delay. Let's say nagkaroon ng demand. In spite of the demand, hindi pa rin ginagawa yung obligation. All of the solidary debtors are liable even for loss after a fortuitous event. No? Let's say merong delay tapos nawala after fortuitous event. In that case, kahit fortuitous event yan, kahit specific thing yan, okay, the solidary debtors are liable. If example, A, B, and C promise solidarily to deliver to D a particular truck valued at 1.5 million pesos. If the truck was lost through a fortuitous event, but after a demand was made upon C, D can still recover damages from A or B or both of them. Okay? Kasama rin dito si si A o kaya si B, pwede rin habulin. Okay? Kahit na ang binigyan niya ng demand letter si C lang. Okay? Because a demand to C is like It's like a demand to the whole to all of the to all of the solidary debtors. Okay. The latter can ask for reimbursement from C. Si A at saka si B, they can ask for reimbursement from C, the erring solidary debtor. Let's go now to divisible and indivisible obligations. What is a divisible obligation? A divisible obligation, the object of the obligation is capable of partial fulfillment in its delivery or performance. So, an example nito? Payment of money. No? Money is actually divisible. You can divide money even into centavos. But class, take note. You have to determine the intention of the parties, not the object itself. Okay? Kasi paano kung ang obligation, ang contract ay straight cash payment of let's say 10,000 pesos, hindi yan pwedeng hatiin. Alright? Because ang intention is to pay 10,000 pesos straight. Okay? Indivisible obligation naman, the object of the obligation is incapable of partial fulfillment in its delivery or performance. Example yan, delivery ng kotse. So dapat buo yan. No? Pwede rin bang cash maging indivisible obligation? The answer is yes, if that is the intention of the parties. When there is only one creditor and one debtor, the debtor has to perform the obligation in its totality, whether or not the prestation is divisible or not, unless the parties agree. So class, ito, no? Let's say may obligation ka na magbayad ng 50,000 pesos. Hindi mo pwedeng pilitin yung creditor, o pwede ba, pwede ba 25,000 muna, tapos 25,000 bukas. Hindi mo pwedeng pilitin yung creditor na gano'n. Kapag pumayag siya, walang problema, pwede. Pero hindi mo pwedeng ipagpilitan yan. Parang let's say pupunta ka sa tindahan, no? Tapos marami kang gusto bilhin ng mga gamit. Hindi mo pwedeng pilitin yung nagbebenta na hulugan lang yung bayad mo. Hindi pwede. Okay? The creditor cannot be compelled to receive the prestations partially. Effect of non-compliance by a debtor in a joint indivisible obligation. We already mentioned this earlier, but let's discuss this again. If any one of the joint debtors does not comply with this undertaking in a joint indivisible obligation, the obligation is converted into one for damages. So pera na lang, yung money equivalent na lang. The creditor cannot ask for specific performance or decision because there is no cause of action against the other debtors who are willing to fulfill their promises. Let's say si A, si B at saka si C, they oblige themselves to deliver a car to D. Si A at saka si B gusto na mag-deliver, si C ayaw. Kapag hindi pwedeng ma-deliver yung car kasi merong umayaw na joint debtor. So pag ganyan, the obligation is converted into one for damages. Pera na lang ibabayad. Tapos may additional damages dun sa ayaw pumayad. Okay, class, let's end here. We shall be discussing obligations with the penal clause next. Take care, God bless, and keep safe.